Again, my name is Matthew Finch. How are y'all doing? I'm the last presenter of the day, and I'm going to rush this myself as well. I graduated from St. Mary's Law School in 1999, so I'm a hometown person here. I've lived and practiced in the juvenile court system and probably litigated a couple of hundred due process hearings in the state, and in Texas, it is the Wild West. Several years ago, if everybody knows of the Appleseed Foundation, they're out of Austin. They were doing a fundraiser for some of their great projects that they do. This is hanging in my office. The statement says kids treated as criminals behave like criminals. Of course, there's other things, zero tolerance, off court stuff like that. I think we all kind of live and breathe this stuff as we're dealing with the kids that are our clients. Um, Obviously, the law is pretty straightforward. Education Code, Chapter 37. I think in the future, I'm gonna lean a little bit more on the idea, especially with all of the new state laws and the discipline and stuff like that. They're gonna have to figure out how they're gonna answer that particular issue there. The student code of conduct. Uh, that's kind of important now too. How many art meetings have we all been to where they just kind of gloss over and just already pre-check the box? Yes, your client can follow the student code of conduct. I've made eyes roll in art meetings dozens of times whenever I just say no. And after 10 or 15 minutes of the discussion is either I'm going to disagree with you and then we can sort it out some other time, or we're going to have a more thorough discussion uh, moving forward. Um, yeah. A lot of the types of cases that I deal with are the kids that are ADHD, that are impulsive, that pull the firework, that get into a fight because somebody said something they didn't like, or uh, the autistic kid who has that they want to be friends with everybody, so their friend lets them, hey, just hold my marijuana here for me while I'm at school, and of course he gets in trouble. Or the kid who has a behavior intervention plan and who has a chill pass, and the substitute teacher is in class that day, and he tries to use his hall pass, and the teacher blocks the door, so there's an altercation and somebody gets hurt, usually the teacher. Those are the types of referrals that I deal with that are getting into the juvenile system. Uh, I've had several clients as well that are the kids that are bipolar, dealing with some pretty serious mental health issues, right around the 12, 13, 14 years old, where it might not be diagnosed and they've kind of started having these behaviors. And it's really impulsively quick. They just send them to the juvenile system. The child find obligation is really important in cases like that, because generally speaking, uh, a lot of these cases I get involved after they're already sitting and they're talking to the juvenile probation department or in juvenile court with a filed case. And I like to backtrack and go back to the school and kind of figure out, hey, what happened? What was going on? Uh, Utilizing IEPs and making sure that they're really nailed down, especially the behavior aspects of it moving forward, I think are really important. And just really focusing on being aware of what the particular child's behaviors are going to be, because you need to address them up front, because at the end, when they do the behavior, which we all know they're going to do, you'll be able to say, no, I told you so. And we discussed it and y'all chose not to do it. Briefly touch on search and seizure. It's been talked about a little bit. Obviously, everybody's read the student code of conduct that their students have to sign, and they give away a whole bunch of freedom. You bring a backpack to school, if you have a locker, the school's going to search it. You're getting into public policy. The schools have to keep safe campuses. So you lose a lot of those rights. Statements, admissions, that type of stuff. There are laws in place in the juvenile system that they have to be taken to an appropriate juvenile processing center. There are certain requirements. It's been touched on briefly as well. It depends on whether or not it's a teacher, an administrator, or the campus police officer is doing that. Never consent. Tell every one of your students, every one of your clients, you don't have to talk to the police. You're going to probably take a ride. You're probably going to get removed from the campus, but learning to be able to not to be respectful and say, I'd love to speak to my lawyer or my mom, my parents. A funny story. I did have one student one time that I sued the school. We were working on some stuff, and I didn't realize it. And a month later, he was back in school and doing that stuff, and he literally pulled out my business card in class. I don't know how you're going to teach a 10 or 12 or 14 or 16-year-old kid to be able to navigate saying, no, I don't want you to search my stuff. Teacher, principal, obviously, you know, there's things like metal detectors. I don't know if they use drug dogs anymore. I see. When I was a kid in high school in the early '90s, we were one of the first schools in the state of Texas that started trying to do that kind of stuff, and even tried to implement drug testing for some athletes and stuff. It's ultimately at the end of the day that well, there's black and white in the law. There is no black and white area of this law. It's all gray area. And at the end of the day, you can make the arguments. There's case law out there, but at the end of the day, maybe a judge is making a decision on whether or not it was a proper search or admission or something like that. We've already kind of talked about some of this stuff here. Yeah, the new HB6 with the being able to do the ISS, that's going to be an area very ripe for litigation. And that's when I say leaning on idea, the pattern of removals, the 10 days, it means something in that law. The state will figure it out in their discipline laws moving forward, because it's going to have to be hashed out. It's going to be very inexact, but I can see a huge issue that's going to happen there, because they're already going to be sending all the discipline kids out that they don't like right off the top of the list. And they're going to keep them there as long as they can. So there's going to be a lot of litigation in that issue.
Do you have any thoughts on, I had a student who's autistic, and he was asked to hold the vape. And he held the vape, and then they called in, the kid who had the vape called in, it's our supposition, and reported that he had a vape. And of course, he was arrested. And so there's a lot of systems within the school that are there to protect, but making a claim to a police officer, a false claim to a police officer, it's ignored because it's an anonymous system that the kid goes to say.
Well,
It's just a thing. Yes, it's
well,
a setup and
every single time it's a setup. I mean, it's a sad situation, because the kid that is holding it, that's the autistic kid that probably doesn't even have the intent to possess a drug, much less know what it was, is the one that's going to take the fall. Luckily, a lot of those cases are MDRs, because it's the zero tolerance of all the guns and drugs and everything else that we have on campuses today. I have had a little success in going back in an MDR and, you know, really, you guys think he knowingly possessed this on campus? Vape pens, the THC, the law and science are just kind of leapfrogging right now. It's a mess, you know, and now the legislature in Texas is going to go back and make everything illegal again. But that's an area that's ripe for litigation as well. But unfortunately, you know, schools, public policy, it's overwhelming, especially in San Antonio. I mean, I see 2 or 3 cases a month of kids getting caught with vapes on campus. And then, you know, last legislative session, they decided, yeah, automatic expulsion. Then they realized, oh my goodness, we just overwhelmed another system because of what we're doing. Now we're going to give more discretion back moving forward to the schools. Yes, ma'am.
What about false P3s?
well, that's good. P3 is the anonymous reporting system.
Yeah, I mean, if the child has the stuff on them, they're guilty. But if I keep calling in a P3 that Susie and Jennifer are doing whatever, and they're really not, but I'm that evil person that's bullying them this way, when is it enough?
When you yell out, when you force the issue, you have a full blown discipline hearing by the local vice principal, who is already kind of predisposed how he's going to rule on the kid who got caught with whatever it was and all that stuff. But you know, it's all going to get hashed out. I think at some point, you know, you'll just have to have your day in court. And obviously, a lot of times in my practice in the juvenile criminal system, you kind of have to choose because there's a split. You're either going to go get punished by the school, or you're going to go to the juvenile system. you can make an argument depending on the specific facts about do you want to try to keep it on the school campus and maybe take a little harder hit there, then get the referral to juvenile or vice versa, or do you want to get him out of the school to do that?
But I found out that when they call in this P3 anonymous, it goes to a different state, goes to Oregon, then it goes to the administrator, and the administrator call in to.
Yeah, with technology and social media and everything else, now I'm gonna talk about that in a minute too, but it's bizarre how some of this stuff is coming in and being reported. When you're at the discipline hearing, when you're in an art committee, whatever it may be, you're able to talk about why you shouldn't punish a particular student for whatever reason, obviously. Chewing gum on campus is different than bringing a gun. So the seriousness of the offense or the infraction, is disheartening for me. The juvenile system at age 10, the law says that children are inculpable. So you can be referred to the juvenile system as early as 10. And when you have a 10-year-old kid that's accused of this horrific crime and he can't even see over the bench to see the judge, it's crazy. But the path of least resistance, that's how schools get rid of their problems. They send them to the juvenile system. Self-defense, obviously, that's an assaultive behavior. There's hundreds and hundreds and hundreds of fights in schools every week, and then it's usually the special needs child, the one that hits back, or the one that always gets caught as well. Obviously, and then the area that we play, the disability, whether or not the student has a disability that substantially impairs their ability to appreciate.
Matt, can I interrupt you? There
Sure.
for a second? Let's go back to that slide. I have had this question forever, and I've kind of asked it to y'all and everybody else. Okay. Can you speak a little louder? Yeah, so you have the NDR. The standard is whether the student, this behavior was a manifestation of a disability. And or was it a failure of the school district to implement their VIP? It doesn't have in it, what happens if they should have had a VIP and they did?
Well,
Uh-huh,
then you just kind of pause the discipline process and you sue the school for a child fine.
right, but it's not an NDR, right? Or is it?
You can have MDR without VIPs. Absolutely, that's where, my understanding, Martin?
Well,
No,
No.
but I've been to MDRs
Well-
without the VIP, then we so-called the steps for ordering the FDAs, blah, blah, blah.
in that particular situation, if they were going down that path, I would tell them that you do not have enough information because this is a child with a suspected disability.
Yeah.
In a manifestation process that you need to pause and you need to go get some evaluations done because you don't have enough information to decide whether or not you can answer that first prompt. That's usually how I've approached it as well. And talking about NDRs and stuff, and I'm kind of skipping around. 3 times in my career, 3 times in 25 years, I've actually had a manifestation that came back and said it was. And when they're pending the juvenile court, and I'll tell you what, the smile on my face walking into juvenile court and handing it to the prosecutor, all of those cases have gone away. 3 out of 100, at least. Yes, ma'am.
We're talking about, if you remember when you and I met, my son with autism, through a criminal citation, what did we do? We subpoenaed every person in the AR.
I'm from San Antonio. I got hired for a truancy case in JP court in Fort Worth area. And I showed up and there were 3 prosecutors stood in the room talking. I was sitting down and they were standing up talking to me. I said, I need a special setting. How do I issue 20 subpoenas? Because everybody at that school didn't do their job. After about 30 minutes of phone calls, they said, what if he just stays out of trouble for 3 months?
Right. Yeah.
Sometimes you have to be the loudest person in the room. It's not all touchy-feely, like singing kumbaya stuff. And I've never been involved in a case where we show up and everybody's hugging each other. A little bit about it, obviously and you're talking about kids that have special needs. In San Antonio specifically, I think that's generally how it works. 5 minutes. The probation department does all the intake and it makes the decisions. I mean, there's certain categories of offenses, the more serious stuff get automatically direct filed. The probation department in Bear County gets the referrals. They go out, talk to the families and this and that. They could do a couple of things. At ACR, they basically come into the office, hey, you kind of did this thing, don't do it again, go home. Deferred disposition, they don't refer it to court. You sign a contract with the probation department or the DA's office, and they provide whatever services they feel are appropriate. Kind of getting past all that, and sometimes it happens, unfortunately, when all else fails, your client goes on probation. That could be placed on probation in the home. Placed in the care of the chief probation officer, meaning for like placement or something. Crier is the facility here. It's a mental health facility. They can be placed outside of the home for drug treatment. And then if they're really bad or the system doesn't appreciate that they can remediate the situation, by the time they turn 18, they can send them to the TJJD, Texas Juvenile Justice Department, for a determinate or undeterminate sentence until at least they're 19. The TJJD probably is the largest population of special ed students in the state of Texas. I actually also do a lot of work with Child Protective Services cases. I have the privilege of being appointed by the court as a surrogate parent. So I get to go to the schools and when they don't do what I ask them to do, I say, well, I'm going to go tell the judge. But I see a lot of, so I've even got 2 cases with 2 kids that are in TJJD right now, and I'm having hard meetings for them. Whether they're going to follow through with anything, that's a different story, but it is possible. The juvenile system is the focus is rehabilitation, providing services to make the kid be successful and not have any more problems and not continue to be referred to the system. The juvenile probation department also prepares what are called predisposition reports when you got a kid pending court, and they go in and look at the home, they talk to the family history, any work or school history, mental health history, drug history, and then they make recommendations to the court to what you can do. In this regard, the juvenile probation officer who is working with the family is it's so important to be able to provide all of the documents, the treatment providers, the psychologicals. If you can go into that first meeting with the juvenile probation officer and explain to them, this is really a big misunderstanding. This is an isolated incident. We have all of this stuff taken care of. My child, the student is receiving mental health treatment. They're on their meds. This is just a freak deal. We don't need y'all's help. Can we do something different? Obviously, their hands are tied in certain situations as well, but to refer it on to the court. But a lot of times the juvenile probation department, if you set it up right, the process can stop there. They will address the issue and it won't get referred to court. Obviously, just a little bit of legal stuff here. It's a civil court. The family code and the penal code are kind of controlling. A juvenile pleads true or not true. It's not guilty, no contest. They're referred to as a respondent, not a defendant. Obviously, the judge could do some certain things. They could say, you've pled true, you've admitted to it, but we're just not going to do anything. You can go home because we think your needs are being met. Obviously, probation and at home or in the custody of the probation officer, DJJD. Something else in the big picture as well, if your only win is at the end of the day is you're going to be able to have a record sealed when the kid gets off of probation and stays out of trouble. That could save people's lives and let them go to college and get careers and all of that as well. Judges have discretion in that. If you have a good working relationship with your local judge, they're more likely to do that. In my experience as well, if you're going into of course, I'm pretty well known. I've been doing this a long time. All of the juvenile judges, the CPS judges know what I do. And if I walk in and literally say, Judge, this is the issue, or I go in and say, Judge, this is what I found out, and can you believe it? I had to go and sue the school district because of all the screw ups they did. Get a little bit of deference there, and they'll actually understand and work with you to do all that.
You have about 5 minutes to wrap up. I'm sorry, we've got to lock the facility.
That's fine.
5 minutes.
Thank you.
We don't want to get arrested. You're not allowed to bail us out.
Obviously, fitness to proceed is a competency. Can they work with a lawyer? Do they understand the process? That kind of stuff. That's under Chapter 55 of the Family Code for a youth that is having some mental health issues. They might not be able to understand and assist their lawyer. That diverts it from the juvenile justice system into treatment and that kind of stuff. And obviously, the other thing, responsibility, substantial capacity to appreciate right from wrong, conform their conduct to the requirements of law, do their mental health or mental illness or intellectual disability. That's sanity at the time for the adult system. With that, yes.
The one thing I think would be really important is that the kid is being deferred to the system. It's imperative, I think if somebody's got a juvenile order, it's imperative that they want the education correct. It doesn't have to come from the so.
No. Oh, absolutely. And that's part of the probation department as well. All of them have the liaisons with the schools, but yeah, getting those school records and being able to show to the prosecutors and probation is what the real issue is going on, because they get cases off, just floating through their desk and rubber stamp stuff. So it's important to kind of humanize your clients and make sure that they realize that there are some other avenues besides the juvenile justice system.
Okay, listen, thank everybody for being here, and virtual there. We thank our friends from St. Mary's for supporting us and providing this today. I want to thank Robin Petty. Where's Robin? Robin, for all the work he did on getting all the computer stuff set up, and his beautiful assistant, and he's not paying her enough. Right now, he's not paying her enough. We're gonna do this again. I want to thank the speakers. I want to thank the speakers who came to speak and didn't speak. And for everybody being here, be safe. God bless.